Hello, this is Paul Zambi. I'm an attorney with Texas Legal Services Center based out of Austin, and I'm the managing attorney for the Transfer on Death Deed, and that's what we're going to be talking about today. Transfer on Death Deed is a fairly new law enacted on September 1st of 2015. It is going to be a wonderful financial tool for folks, and especially for the low-income folks that we can serve. What it does is it transfers your property outside of the probate court, just like a life insurance policy, so it gets to skip all of that hassle. It does have its own statute. This is a Texas law. It's Chapter 114 of the Estates Code, and about half of the states already have one of these. So we're not the first, we're not the last, we're kind of in the middle of the party. Again, about half the states have one. The Texas law is for land located in Texas. We have 254 counties. If the land is located in one of those counties, this is for you. Just because you lived here, if you've lived here for 5, 10, 15, 20 years, whatever it is, but you own land outside of the state, Oklahoma, Arkansas, Maine, whatever it is, this law is not for you. Again, you have a 50-50 chance if one of those states has a transfer on death deed or a beneficiary deed. They're the same thing. But this Texas law would not be for you. All the laws are probably a little bit different. You would have to contact an attorney in that state or some way to see if they have a certain form for that state. Conversely, if you do live in Arkansas, Oklahoma, but your land is located here, but you've never resided in Texas, you've lived in one of those states, this law is for you. So again, the determinant is where the land is located, not your residence and not where you reside. Texas has had a huge problem in the past with something called clouded title, and that is when somebody dies owning property, but they pass away without a will. So what happens is a judge is going to have to decide who owns that property at some point in time. So if somebody dies without a will and they've got 3 or 4 kids, they all own 1/3 or 1/4 of that property. If those kids also die without a will and they each have 2 or 3 kids each, after that second, third generation, you can have, 10 or 12 people owning a fractional interest of the property. And when one wants to try and sell it or get a loan on it or something along those lines, they're not going to do it because you need all signatures if you're going to take action on a property. So again, clouded title, a huge problem in Texas. So Texas has recognized that. They have made something called the transfer on death deed to make it more easy for people to do that. So in the first place, you've heard that saying everybody should have a will. Well, a lot of people don't have a will. Why is that? It could be the cost. Wills can be up to $200, $300 each or more. Sometimes it's a superstition. Some folks feel like after they do a will, their time is going to be up soon. Even if they do have a will, sometimes their children do not probate the will, and that's for several reasons. First of all, the cost. They may know that it has to be done, but probate is at a minimum $1,000 or $2,000, and they may not have those funds. And the reasons that they can get away without probating the will is this false sense of security that's actually caused by the tax authority. So if you have an 80-year-old parent who's living with a 50-year-old son or daughter who's taking care of them, and that parent dies, the first thing that the child is going to do, or they think about doing, is going to the tax office and saying, hey, my parents died, here's the death certificate, can you put my name on there? And the taxing authority will be happy to do that. As long as they get paid, they'll take money from an old brown shoe. But because the child is now on there, they could be on there for 5 years or 10 years, and they'll say to themselves, well, I'm on the tax roll only, I'm paying the taxes, it hasn't been foreclosed on, I own the property. That's not how it works. If they go try and sell it the next day or get a loan on it, the title company, mortgage company, they're going to want that deceased person's signature, and obviously that's an impossibility. So it is a false sense of security when you get that tax name switched over to your name, because that has nothing to do with ownership of the property. All that does is it prevents the property from getting foreclosed on. And I don't know if anybody here has ever had to help anybody through probate, but again, The name of the game is to avoid that if you can, and this is a great tool for doing so. If anybody has had to gone through that, whether it be yourself or helped a loved one or helped a friend or neighbor, it's been described anywhere from a pain to a nightmare. It's not quick, it's not cheap. Again, avoiding it is the best thing that you can do. And again, let's say that a judge, because somebody didn't have a will, gives it to 3 children. Let's say that those kids don't get along. Let's say one of them wants to keep the property that was passed to them, one wants to rent it out, and one wants to sell it. If they can't agree, they may start fighting. One of them may say, hey, I'm not going to pay my share of the taxes or the mortgage or the maintenance. That burden shifts on to the other 2 who may be unable or unwilling to take on that extra burden. And we've actually seen them throw up their hands because of these issues, because even though they're having to pay, they can't sell the house because this third person's name is on there. And we've seen homes get abandoned, whether it be for tax purposes, mortgage purposes, just whatever it is. So it's an issue. So the main focus of the transfer on death deed was to unify title. And in general, again, there's always a family dynamic, but in general, it's better if fewer people are on the title to a property than more people. It just makes things a lot simpler. So, enter the Todd. Again, it's a wonderful tool. It can save you hundreds on the front end by not having to have a will, because this, for all intents and purposes regarding real property, will transfer your property more effectively and efficiently than a will. That's on the front end. You don't have to have one. On the back end, if one of your family members doesn't have to probate a will, it'll save them thousands of dollars, because even an uncontested probate is going to be $1,000, $2,000. So that is a huge benefit for them. And again, that's one of the reasons why some of them, even if there is a will, don't go down to the court and probate it. But one of the biggest savings and something that most people are most excited about is that if you transfer your property with a transfer on death deed, it actually exempts it from Medicaid estate recovery. And we're going to be going over that at the end of this seminar. It'll be some of the last few slides. But again, if you can save your house by not having to have it subject to a lien from Medicaid, then you've saved your house and you actually get to pass it on to folks. So the benefits of the Todd are that it saves all that money, it avoids splintering of the estate property, not only the right to something, but the title to something, your home or your land or whatever passes on to the next person. Because even if you're left something in a will and that person dies, you can stand up on a chair and you can hold up the will. Hey, I own a property. You don't own that property yet because there's some sort of court action that needs to take effect, and that's usually probate. So then you go down to the probate court and you say, Judge, I have the right to own this, and then he, along with the administrator or the executor of the state, will effectuate that and actually put title in your name. So there's a difference to the right to something and title to something. Transfer on death deed does both. It gives the right to something as well as title to something, again, outside of the probate court, and again, more inexpensively and efficiently than a will would do. So we get those calls all the time. Hey, Paul, I know there's this new law here. I have a will. I don't really need this then, do I? Well, yes, you do, for the reasons stated, that it's more inexpensive and efficient to do it that way. There are some times when you may need a will. I mean, a will is a great fallback. So also, if you have extensive holdings, other financials, other property, a lot of personal property, corporations or something like that, it's possible that you may still need a will. For our clients generally, low to modest income folks who we help, this is perfect for them, and they usually don't need a will after that. And again, if you have, a little more property, whether it be real property, personal property, whatever it is, it's possible that you may need a will. But again, for our clients, this actually has negated the need for that. So who qualifies for the transfer on death deed? It is anybody with land in Texas. Okay, as I explained, it is not for land outside of the state. It is only good for real property. Real property is your land, your home on the land. That includes mineral rights, timber interests, and even cemetery plots. It does not include personal property. Personal property is property that can be easily moved from a home. Tables, desks, chairs, furniture, jewelry, clothing, things along those sorts. So again, if you have a lot of that other stuff, it's possible you may still need a will. If you can figure out who to give that to, and if everybody agrees who gets what, again, you may not need it, but it is for real property, not for personal property. So one of the issues is we have those calls, Paul, I'd like to do these. Yes, I have a land and there's a home on the land. But after some questioning, we determined that that home on the land is actually a mobile home or a manufactured home. So it wasn't built on the land. If it's built on the land, it's real property. If it was placed on the land, odds are that's going to be personal property. And there's certain ways that you can get that transferred back over to real property. But initially, if that's personal property, that will not be passing with the transfer and death deed. So again, that is another issue you need to take care of to get that personal property re-itemized as real property. It is one tod per property. So if you own more than one piece of property, you're going to have to make more than one transfer on death deed. The law in Texas is for any age and any income. I mean, of course, we can do it for those, low income folks, and the baseline we use is 125% of the federal poverty guidelines. But again, that's just when we can do it for free for folks. The law in Texas, again, any age or any income. A big thing is it cannot be executed by a power of attorney. So power of attorneys are wonderful. They're useful things, especially the financial, durable, general power of attorney. But if you have one of those over somebody else, you cannot execute a transfer on death deed for them. So again, there may be some other solutions for that. In order to do this, you have to understand the nature and consequences of your action and be competent to sign. If you're not competent, you can't be doing a transfer on death deed. The property must be owned outside of a trust or corporation, so it has to be owned by an individual. If you've already done a little bit of estate planning, and because it's a rental home, it's owned by a corporation, or if you originally wanted to avoid probate, so you put it in a trust, you can't do one of these. It has to be owned by an individual, and that's defined by the statute as a person, not by an entity such as a trust or a corporation. And we also get those calls, Paul, I'd like to do one of these, but I don't own the home outright. Can I still do one? And the answer is yes. Any interest you own in the property is going to pass, even if it's not 100%. So there are two examples on that. You own it with a spouse, a child, a neighbor, a friend, whoever it is, you own it 50-50. Well, yes, you can do a transfer on death deed. It's going to pass your half cleanly. Hopefully the other person's going to do the same, but they don't have to, and they don't have to even choose the same beneficiary. So you can leave it to one person, they can leave it to somebody else. But just because you don't own the thing 100% doesn't mean you can't do a tithe. You still can. The other example of that is that one person owns it and they have only paid off 70% of the mortgage. So it's a $100,000 mortgage, $30,000 is still due and owing. Yes, you can do one. If you execute one of these and file it, if you pass on the next day, you're passing an asset of $70,000. You will be passing an obligation of $30,000 as well. They will just be stepping into your shoes, but you are passing an asset. So you can do it whether you haven't paid off the house or whether you don't own the property outright because you own it with other folks. You can still do one of these, and it is still going to benefit you greatly. On the other end, who you leave it to, you have a lot more leeway there. So on the front end, if it's just you have to be an individual to pass it on the back end, you can leave it to one person, 5 people, whatever it is. You can leave it to a trust. You can leave it to a corporation. You can leave it to a charity. Anything you want. So you have a lot more leeway on who you leave it to as opposed to who actually executes the property. And again, let's say that you have 5 children. Well, again, you're allowed to leave it to all 5. Again, I might caution you, in general, it's best if fewer people own it than most. Because let's say that you do leave it to five, well, that's when you really find out if you get along with your brothers and sisters, right? Because if one of them doesn't agree, they can start fighting, and they might, again, not pay the taxes, might not pay the upkeep, might not pay the mortgage. We've heard that, call so many times. Paul, everybody got along great until mom or dad passed away, and that's when the fighting started. So again, your family dynamic may be such where you really trust that one person to know that they will, divvy it up and share it with everybody, or your family dynamic may be such, we call it the mama loved you best syndrome, and you get offended, where you have to leave it to all five, or else those that you don't leave it to are going to be getting offended. And again, you can do either. You can leave it to one, you can leave it to all five. You choose. You don't have to leave it to any of them. You can leave it to a neighbor, or again, a church member, whatever it is. You have that leeway. The requirements of the form, fairly easy form. I mean, you need names and addresses of both the grantor and the beneficiaries. The most difficult part of the form is getting a correct property description. If I was to ask any of you what's your property description, you would probably immediately go to that yearly tax statement that you get from the tax assessor's office. That is not where you get the property description. That is usually inaccurate or incomplete. A lot of times the people transcribing that down to the county tax forms, they may only have half of a line or maybe one line. And some of these property descriptions can be pages long, at least a paragraph long, but sometimes pages long. So again, where you get the property description is very important. It needs to be gotten from a previously filed deed. Okay, the one, typically the latest one in time, so it's the one that would have given them ownership and title to the property. The deed has to be notarized. This is unlike some of the other forms that you're hearing about which need to be witnessed. This does not need to be witnessed. It does have to be notarized, and then it has to be filed in the county where the property is located before you pass away. So again, it has to be executed and filed while somebody is still competent and before they pass away. Big points there. We've had those calls. Paul, my husband died a month ago. Can I do anything about this? It's too late for the transfer and debt deed for his purposes in that case. A big question, though, is do you need an attorney to do one of these? So here's the deal with the transfer and debt deed. There's a statutory form you can look up in Chapter 114 of the Texas Estates Code, and they've provided a form for you, okay? So obviously it's always best if an attorney does something just for accuracy's sake, okay? And again, we can provide that service for those folks or families who are under 125% of the federal poverty guidelines. Other attorneys are going to be doing these, and they can charge whatever they want. You are allowed to do it yourself. And again, online, we have a wonderful form with a lot of instructions, so you can do it yourself, and that's found at texaslawhelp.org. And again, wonderful form, great instructions. So you can get an attorney to do it for you, whether it be free like us or whether you pay somebody, you can do it yourself. What you shouldn't be doing is preparing that for somebody else. And especially for those folks like social workers and benefits counselors, they love to help people. They help people in many different matters. You should not help somebody fill this out. That crosses over into the unauthorized practice of law. If you make a mistake, there can be consequences of that. Consequences regardless with the unauthorized practice of law. So somebody can do it themselves. Somebody can have an attorney do it for them. You, as social workers or benefits counselors, should not be doing this for somebody else. Quick point on TODS versus a will. Again, with a will, which again, you've always been told that's the base that you need. And again, in certain circumstances, you may. With a will, you need 2 signatures notarized. You're done. You stick that will under your mattress. 30 years later, you pull it out. That's a perfectly good document. It doesn't have to be filed anywhere. Not so with the transfer and debt deed. The transfer and debt deed has to be filed. It does not need witnesses. It does have to be notarized, but then it has to be filed in the county where the property is located. If you properly write it out, fill it out, even notarize it, but then you stick it under your mattress, it's not worth a thing. You have to file it, county clerk's office, before you pass away. That's a huge thing. Also, the provisions in a TOD trump that in a will. A will is just for all the leftover stuff. So if in a will that you did 2 years ago, you've named little Johnny to get all your property, but now Johnny has maybe grown up and he's either won the lottery, he doesn't need it, or he's gotten on drugs or something and you don't want him to have it. If you do a transfer on death deed now, even if you don't change your will, and if you name Susie today to get your property, that's who gets your property. It's the provision in the TOD trumps that of a will. So if you have a will from 30 years ago and you have one from today, latest one in time rules. Though the one 30 years ago is now null and void, it's the latest one in time. It's going to be the same with the transfer on death deed. If you do one 6 months ago and then you do one 6 months from now, the one latest in time is going to rule. But not so with a will versus a TOD. If you do a TOD today and then you do a will next year and you leave it to somebody different in the will, in the TOD, so in the will a year from now, again, you leave it to Johnny, and in the TOD you've left it to Susie, Johnny doesn't get that. Even though the will was later in time, the provisions in the TOD trump that of a will. Having said that, if you do have both, or if you did a will a while ago and you've named somebody different to get your stuff, you should really avoid that inconsistency. You should sync them up. You're just inviting a lawsuit then, because somebody, even if they don't know the law, is holding up a will which gives them, title to or the right to the property. Nothing stops them from filing a probate action. I mean, obviously, when the TOD is introduced, that's the document that will prevail. But again, it's not going to stop those hard feelings and possible waste of money. So if you have an inconsistency there, you should probably sync it up. And again, just like a TOD, you can, with a will, you keep the original, but you disseminate copies to everybody. With a TOD, it's on file down at the county clerk's office. So you should probably tell others that it's there. But again, at that point, it's actually public record. So if you ever lose your copy, or if one of your kids wants a copy, whatever it is, they don't necessarily have to get it from you. They can go down to the county clerk's office and they can get a copy of that. Once it's filed, it's there forever. It's public record. What is the effect of a TOD filing? Once you execute and file a TOD, it has zero effect right now. It is only effective upon your death. It's a transfer on death deed. So while you're still alive, you own all the ownership rights as if you've never filed anything at all. So the rights, you have the right to sell that property, you can get a mortgage on that property, you can do whatever. The responsibilities, you've got to pay the taxes, pay the mortgage, do the insurance. Just because you've named somebody as a beneficiary doesn't mean that they have the right to chip in for any of that. But again, you don't have to, on the other hand, you don't have to ask them if you can sell the house just because you've named them as a beneficiary. You retain 100% ownership, and until you pass away, zero interest passes on to the next person. So there is no interest in the beneficiary. So let's say that a beneficiary wants to get on services. This will not count as an asset for them until the person passes away, because nothing has passed. By the same token, there's a protection there. Let's say that the beneficiary has a lot of creditors out there. Well, they cannot attach to your home that you have, executed a transfer on death deed on, because it hasn't passed. So a creditor of a beneficiary, while the grantor is still alive, cannot attach to that property. All right, so what happens when somebody passes away? How do you receive the property? Well, in the real world, you would actually file the certificate of death that the county issues, as well as an affidavit of death, swearing that that person has passed away, and you would file it in the same place that the TOD was filed, and out in the county clerk's office where the property is located. That's what a title company looks for, a mortgage company. If somebody wants to get a loan or if somebody wants to sell the house, title company doesn't call up people and say, hey, tell me what the story is here. They want to look to see what the record is at the county clerk's office. So when they go in there and they see that originally filed transfer on death deed, and then they see the certificate of debt and the affidavit of debt, that's what they're going to use to transfer the property into somebody's name. And again, I briefly touched on the fact that the transfer on death deed exempts the property from a Medicaid estate recovery lien, and that's true. And again, I'll be going over more of that in a little bit. It's not a magic bullet for other things. If you have a child support lien, if you have a house lien or a mechanics lien because somebody has done work on your roof and you owe them money, or if you owe back taxes or you're late on your mortgage, all of those things pass. So it doesn't wipe out other things. It just helps with the Medicaid estate recovery, okay? So creditors have the right to reassert their claims after 2 years, 2 years of the death. One thing, when you pass it on, a lot of people ask about the stepped up value of the home. So they're worried about the home being bought for $30,000 in 1980, and now when they pass it on, it's worth $500,000. And what if the person getting it wants to sell it the next day? Are they going to have to pay the difference in taxes possibly from that $30,000 value from the $400,000 or $500,000? No. Very similar to a will. Once it passes over at the stepped up value of that. So the base value is now that $400,000 or $500,000 that the home is worth. A quick note on separate versus community property. So everybody knows about community property in Texas. Every dollar you earn is 50 cents of that is his or hers, and that's how it goes in Texas. That is money earned during the marriage. Okay, so earnings during the marriage, community property. If you buy a home together while you're married, that home is half yours and half his. Okay, so an undivided 1/2 interest. So when we're doing a transfer on death deed, we would generally do 2 of them, and we would name each other as the primary beneficiary. So the husband names the wife names the husband, and then there is space for an alternate beneficiary on the form, and that's where they can put their children in there. And it's possible they may, have different forms and they want different alternate beneficiaries, but let's say that they agree and it's the same kids. Well, when one spouse dies, it goes over to the other spouse. Again, no probate court involved. That second spouse now owns the entire property. They do not need to execute another transfer on death deed. When they pass away, it goes down and it skips down to the alternate beneficiaries. So filing at one time, as long as you've named correctly the primary and the alternate beneficiaries, you don't have to do anything new. It all passes on wonderfully. But again, as far as going back to that false sense of security, in Texas, a husband and wife buy a piece of property. They say, we don't need a will, we don't need this or that, because if one of them dies, it just goes on to the other person, correct? That's not necessarily how it works. I mean, especially if there are other children involved from a previous marriage. So you should always have, at a minimum, a will to tell a judge who you want. But more importantly, you should have a transfer on death deed to specifically give the right and the title to that. But again, just because you're married in Texas does not necessarily mean that his or her portion is going to transfer over to you. You have to be very, very careful about that. When we get those calls, hey Paul, I'd like one of these, my husband died a few years ago, what do I do? So first of all, we ask them if there was a will. And they say yes, and our spirits kind of pick up a little bit. Well, you're going to have to go down and probate that will. Yes, it's going to cost time and money, but at least you're going to get that title transferred. And they say, oh, great. Well, my husband or wife died 5 years ago. I'll get the will and we'll go do that. And that's when my spirits drop again, because in Texas, if you're going to probate a will, you have to do it within 4 years. So that's a magic time limit. If it's past that time, it's as if they didn't have a will at all. So you have to watch out for that. The question I probably get asked most is, okay, what happens then, Paul? How do I get their name off of there? and that would involve something called an affidavit of heirship. I mean, obviously you could go and you could pay an attorney and the court filing fees to do what's called a determination of heirship. Again, it's probably done fairly quickly meaning less than a year's time, but it's going to be expensive. The other thing that our clients use most often is something called an affidavit of heirship. It's pretty much the same information. You list all your uncles, nieces, nephews, whoever may have a possible claim to the property, and then it is filed down at the county clerk's office, again, where the property is located. And the funny thing about that is it shouldn't be filed by somebody who can be a possible beneficiary, so it shouldn't be filed by a family member. It's best if that's filed by a neighbor or friend who's known the family for years, or maybe a fellow church member or something like that. And one is better than zero. The title companies really like to see two of those filed. And if those are on file for 5 years, that's what's called prima facie evidence of title transfer. It has to be uncontested. In truth, I have seen title companies accept that even within the 5-year period of time. So again, you just need to get those things on file and get that clock starting to move. And the longer it's on there, the more weight and worth and value that those have in order to change property. So that's community property. Separate property is property that you bring into the marriage. So again, you may have bought your home, even if it's the day before you got married, that's your home, that's separate property, okay? Separate property is also property that you get during the marriage, but not from earnings, it's from gift or inheritance. So if Uncle Wally dies and he leaves you a CD or a home or just whatever it is, that's your separate property. That is not community property. When you pass away, that your spouse may not even be figured in there. So on those folks, if we're going to do a transfer on death deed, we don't need both husband and wife on there. It's just the one person who received that inheritance or has that separate property. And when they name their beneficiaries, it doesn't even have to be the spouse. Again, it can be anybody they want. So a spouse doesn't have any right to separate property in Texas. Okay, a real big point is that the transfer on death deed is revocable. I mean, we get a lot of those calls, boy, Paul, you know, a will was something where I just held under my mattress, but this is filed down at the courthouse. But what if I want to change my mind? I'm not willing to do this, or I'm leery of doing this because it's so final. This is a revocable transfer on death deed. If you want to change the terms, you can do so. And there's a number of ways of doing that. There is a straight out cancellation form. So if you file that, it's just as if the transfer on death deed was never filed, okay? If you file a second transfer on death deed, just like I mentioned before, the latest one in time rule. So if you do one now and one 6 months from now, that one 6 months from now is the one controlling. And again, you may want to do that because one of your beneficiaries has passed away, or they've gotten on drugs and you don't want them to have the home for fear of what they'll use the proceeds for. You know, they've won the lottery, they don't need it, so you want to give it to somebody else, a family member who may need it. There are several reasons you may want to do that, but just keep in mind that the latest in time rules. If you sell the house, which you're allowed to do because nobody else, has to be, you don't need another signature on there, that's a form of revoking it too, because once you pass away, they're going to look to see if you own that specific property, and you don't own it anymore. So the Todd is null and void at that point. And then the last major way of doing it is if you did buy it when you were married, and you're both on the deed, or just whatever it is, if you get divorced, as long as that divorce is filed in the county where the property is located, those divorce papers serve to take off that spouse as a beneficiary on your transfer on death deed. Okay, so then it'll either go to the other primary beneficiary or it'll skip down to the alternates. So again, don't worry about that. If you get divorced, as long as it's filed in the county where the property is located, you're good to go. You've heard of those stories where the dad or the grandma gets the family together, she's angry at them, and she tears up the will in front of them. Hey, I don't want anybody to take under this. That may be perfectly good to signify that person's intent that nobody takes under their will, okay? And then you gotta start from scratch or do whatever. Not so with the transfer on death deed. You wouldn't call people together and tear it up because that's not how you revoke it. It's filed down at the county clerk's office. So in order to do something, you have to do one of those things I mentioned. Do a cancellation, sell the home, divorce, or a new transfer on death deed. Tearing it up does nothing. And again, I'm going to give a little estate planning tip here. Again, I said that the name of the game was to avoid probate. So again, for our low-income folks, this works very, very well. Again, if you have more complicated assets or situation, it may not work for you. But most people have three groups of stuff. They have their home, they have cars, and then they have money, stuff, and other items, okay? So, to avoid probate, if you can do a transfer on death deed for your home, that 1/3 of it, you don't have to go through probate court. That passes it outside of the probate court. For your automobile, there are two possibilities there. The one possibility that exists right now is a Texas Department of Motor Vehicle form, and it's form VTR 122. That's Victor Thomas Robert 122. And that is a right of survivorship form. So as long as that is executed, notarized, filed at the tax assessor's office, not necessarily the county clerk's office, before you pass away, that will serve to not only transfer the right to the car, but to transfer title to the vehicle, okay? So if you've got your house and your car done, you're 2/3 of the way there. Your money. Most people are going to have a checking account. Some people may have savings account, money market, CDs, stocks, whatever it is. On all of those accounts, the financial institution is going to probably ask you who your beneficiary is, okay? If they don't, you need to ask them if they have a place on there where to put it. So if you have one of these accounts, and let's use a checking account, and let's say that only you was on there, nobody is listed as a beneficiary. So that's great. During your life, you get to make all the withdrawals and all the deposits on that. Nobody else has access to it. Nobody has the right to do anything. But when you pass away, if there's $2,500 in there, your kids are going to have to pay $1,500 in court costs, probate, whatever it is, an action, to get that $2,500. And some of them say it's just not worth it. So there are two ways of doing that. One is an okay way. It's where you have a joint account, and it needs to be joint account with right of survivorship. It needs to have those magic words. So those can be very useful. Adult children, age 50 to 60, taking care of their 80-year-old parent, will use that. It's very helpful because then they can make withdrawals and deposits, and they can help mom or dad. The two downsides of that, and you can probably guess this already, is that they can drain the account. So if that son or daughter gets in debt, gets in trouble, gets on drugs, whatever it is, that can and does happen, and we've had those calls. And the amount of dollars lost isn't pretty significant. Also, if the son or daughter gets a judgment against them for big bucks, well, they have access, the creditors were going to have access to that account because it's a joint account in both of their names. So even if the son or daughter's name was only put on that account to help the mother or father, even though all of the money was, the parents', if it's a joint account and the son or daughter gets a judgment against them, that creditor can attach to that. So maybe a better way of doing that is going to be something called payable on death. It's very similar to a transfer on death deed for the home. It's called POD, or payable on death. And that is where, during your lifetime, only you have the right to make those deposits and those withdrawals on that account. And then when you pass away, you've named a beneficiary, so it passes the funds outside of the probate court, just like the VTR 122 for the vehicle, and just like the transfer on death deed for the home. One thing else I will say on the vehicle, so I said that right now the way of doing that is the VTR 122. And again, that's going to pass the right and title to it when you pass away. Effective September 1st, 2017, the Texas legislature has enacted something very similar to the TOD, the transfer on death deed for homes, but this is for automobiles. It's going to be wonderful. I mean, you're going to be able to do the same thing. You're going to be able to name somebody, and again, it'll pass it to them. So, even though the law is effective September 1st, 2017, they haven't made the forms yet. So at last count, the forms are scheduled to be made in March of 2018. Whenever there's an arbitrary deadline like that, who knows? But just know that in the future, after those dates, at some point in time, there is going to be a form, a transfer on death deed form for your automobiles. And we think that's going to be very, very useful and helpful as well. All right. The thing I have not talked about in depth is Medicaid estate recovery. So again, I mentioned that half of my clients like this form just for the simple fact that it's going to avoid probate court and all those costs and hassles associated with that. But again, what people are, I think, most excited about, what the other half like it, and again, it has the potential for saving even more money than that, is that if you transfer your property with a transfer on death deed, it will exempt the property from a Medicaid estate recovery lien. And as you know, that's the lien that Medicaid gets if somebody has to be in a nursing home or gets a few hours of in-home care each week or month or whatever it is. So if you're on those services, whether you've been on it for 1 year, 10 years, or whether you're going to be on it in the future, transfer on death deed is going to protect that property. So huge, wonderful tool. Folks are really excited about that. You know, the caveat is that is under current law. I mean, obviously, next legislature, they could change things. We really think that anything done now might be grandfathered in there, but that is under current law that it will protect it from Medicaid estate recovery. A little bit of history of Merpin, Texas. So before, I believe it is 1993, the federal government gave states Medicaid money, and they did with it what they wanted. They paid for nursing homes, they paid for that in-home care, and that was that. Well, budget cuts and, strains, things like that. In 1993, the federal government enacted a law where all 50 states had to enact a recovery program. And all but a handful actually did. So Texas was one of less than a handful of states that just said, no, we're not going to take homes away from our citizenry. Because, the nice folks at DADS, and they really are for HHSC, they'll come out and they'll see if somebody's eligible for these services. But the first thing that they have to tell them per the law is, hey, you can be on these services, you can be in a nursing home, you can get the in-home services, we'll give them to you free, but just keep in mind that we have the right to take your home when you pass away. So again, DADS has to say that per the law. So Texas didn't do it for 10, 12 years, whatever it was. In 2005, the federal government kind of put their foot down and said, you're going to enact this or else we're going to withhold other monies from you. So the Texas finally enacted the Medicaid estate recovery provision in 2005. And, again, because a lot of folks do know about this, when they go to get services, they'll say, great, I'm eligible. But then when they tell them that they can take their home and they know about this program, they just walk away because they say, hey, even though I really need these services, if when I die, you're going to take away the only thing from me that I've saved up my entire life to pass on to my kids, even if my house is modest at $50,000 or $60,000, I'm just going to walk away from those services. Really sad. If you ever hear of that happening, there is an answer to that. That's the transfer on death deed. Whether it be you, your folks, loved ones, neighbors, friends, relatives, if you ever hear of that happening, this is the answer to that. Okay, so please get them in touch with us or get them in touch with the forms or someone else who can do it for them. Transfer on death deed is going to protect that, and so they can get those services and not have to worry about their home being taken away from them after they pass away. Again, because a lot of folks know about this, they start getting cute and then they get in trouble. So what happens is family gets together and they say, boy, mom and dad is going to need a nursing home in a few years. They're really going downhill. But hey, we understand there's this Medicaid estate recovery program where they can take their home when they pass away if they get a bill. So what they do is they transfer the home and then they, the title to a son or daughter for $10 love and affection, and then they say, haha, Now when they go to go to dad's for eligibility, they won't see the home, and they won't get to take the house. That's the wrong thing to do for several reasons. So the first reason, and the most important, is that when dads checks on you for eligibility, they get to go back 5 years, and they do a very, very thorough search to see if you've given anything away for below fair market value. And obviously $10 love and affection is just that. And they will ding you for it. They will either outright deny you services, or they will make you wait several years, or whatever it is, until they've determined that what you gave away has been used up. So that's the wrong thing to do. Transfer on death deed avoids that. That's the way to do it. Another estate planning tip, the second thing wrong with transferring a home like that is that if you are over 65 years old and that's your home, and you pass it to somebody else who it might be their second home, and they may be under 65, and you're just doing it to avoid Medicaid estate recovery, the younger person is probably going to be paying higher taxes on an annual basis than you did. And the reason for that is two, and this is what a lot of people don't know about. On that elder person's home, they should have 2 exemptions. Everybody has heard about the homestead exemption. Easy form, 1 page, you sign it, you get that deduction. If you're over 65 years old, you should also have something called the elder exemption, or the over 65 exemption. A lot of people don't know about that. So whether it be you, your parents, your neighbors, your relatives, whatever it is, if they're over 65, you need to go home today and you need to check to make sure they have that second exemption. You don't have to choose between the elder exemption and the homestead exemption. You get both of those. But a lot of people just don't know about it, and they hadn't heard about that. So again, that's just money that is going out of their pocket when it doesn't have to be. So again, big thing, if you can transfer that to somebody, that's great. And another thing, one of our programs is a kin care program. The Todd can be very useful in this sense. If you're a grandparent, or one of the people you're serving as a grandparent, and because of a certain situation with your child, whether they're in prison, on drugs, they've lost custody, whatever it is, and now you're having to take care of a grandchild, all right? The transfer on death deed can serve to give the property to them so it can skip that generation. Again, if you pass away without a will, your home, a judge may decide, is going to go to your child. That child who had to give up their child, the grandchild, because, again, they're in prison, they're on drugs, or just whatever the reason, they may be a no-good-nick, and you don't want them to have the home. So if you die without a will, odds are they're probably going to get part of that. If you use the transfer on death deed, you get to direct who your home goes to. And again, if you so choose, you can skip your son or daughter who may be a no-good-nick, who may use the home for less than good purposes, and you can give it to your grandchild, who you obviously have great affection for, because you're now taking care of them. So again, Todd can be a huge, useful tool there. One of the handouts that was given to you is a copy of Form 8001, and that's the Medicaid Estate Recovery Acknowledgement Receipt. And all that is again, that's the nice folks from DADS. When they come out, they explain to you the ins and outs of that, which I'm going to explain the form a little bit here. And they want you to sign it just to signify that they have told you what may happen. And again, what may happen is that if they give you these services, they would take away your home when you pass away. But again, a lot of people who sign that think that they're literally signing away their home at that moment. That's not the case. It is just so the DADS folks can go back and say, yes, this is proof that I did discuss with them what may happen. So if you have clients who are concerned about that, they should have no qualms about signing Form 8001, which explains Medicaid estate recovery. It's not signing away the home, it's just acknowledgement that they've been told what DADS is telling them. But who and what is subject to MERP in Texas? The estate recovery applies to those who are age 55 or older and who initially applied for long-term care Medicaid on or after March 2005. So we've actually known folks who started their nursing home care in 2003 or 2004. Their bill may be $500,000 right now, who knows? Even if they own a home or other property that may be recoverable, they are not under the estate recovery, so their property has been grandfathered in and is safe, okay? It's only if you are on after March 1st of 2005. And again, it applies to all of your estate property which passes through to the probate court. So that's why there are certain things like the transfer on debt deed are so important. They pass things outside of the court setting, and it is not attachable by Medicaid estate recovery. What services are subject to Medicaid estate recovery? You know, that's your basic nursing home services, Star Plus when they come into your home, other home and community-based services, and even some hospital and prescription drug services. So again, all of those, they're willing to give to you free, but the bill is adding up, and that's what they will submit to you at the end. Certain exemptions that are actually listed on the form. Again, that form is only a 2-pager, front and back. There is so much information packed on there. You should really kind of get familiar with it to explain to the folks that you're helping. Again, it's Form 8001. So an exemption, when you pass away, if you have a surviving spouse living in the house, it's exempt. Doesn't matter how much the bill is, that surviving spouse is your exemption. If you have a child or children who are under 20 years of age, or a surviving child of any age who's disabled, so even if they're over 21 but they're disabled, or if they're under 21, that's an exemption. And what Medicaid does is they take a snapshot of your life situation the day that you pass away. So let's say that on the day that you pass away, your spouse is still living there. That's your exemption. They go away, okay? It's not as if 2 or 3 months later, when your spouse dies or maybe goes into a nursing home or whatever themselves, that then Medicaid will come in and swoop again. Your exemption's gone, your spouse has moved away. They don't work like that. It's your situation the day that you passed away. They take that snapshot of your life. If you have an unmarried adult child living in the home for 1 year prior to your death, that is also another exemption. If the recoverable value of the estate is $10,000 or less, or if the recoverable amount of the Medicaid costs is $3,000 or less, they won't attach to it. It's not a big enough asset, it's not a big enough bill for them to go after that. If the cost involved in the sale of the property would be equal or greater to the value of the property, they will go away. So let's say that for whatever reason, the house is so-called underwater, when it's worth more, when the mortgage is more than the house is worth, or where it's darn near close to that. If it's not worth it for Medicaid to do it, they're not going to go through the hassle of selling that to get nothing. So again, those are some great exemptions. The problem with a lot of those is it involves people. And again, people can die, they can move away, they can do this or that. That's what's so great. And then your exemption's gone. That's what's so great about the transfer on death deed. Doesn't matter who's there or who's not there. It's filed at the county clerk's office, and it's on permanent record. So it's a much stronger form of exemption. It's a safer one because it's not likely to change unless you do something to change it. Aside from exemptions, there are hardship waivers. Now this is something that's not given automatically. The heirs must ask for and provide proof of the hardship. Those include if that home or property or land is involved in the operation of a family business, like a farm or a ranch, for at least 12 months prior to the death of the grantor. It also comes into play if the primary income producing asset of the heirs, and it produces 50% or more of their livelihood. So again, that would be a test for the heirs, and again, they would have to submit proof saying that this is how they earn their living, and this is how we earn more than half of our living. That can be an undue hardship. And a recovery by the state would affect the property and the result in the heirs losing their primary source of income. And again, if you do this It's a wonderful thing. They do make a decision, and that's a case-by-case basis. So some may ask for that, they may get it. Others may ask for that, and they wouldn't get it. Another example, if the heirs, if the property was taken away, if they would then have to become eligible for public or medical assistance. So having that house there kept them off of the welfare rolls or something like that. If the house was sold, they would be on it. Medicaid is not going to take their home at that point. And also there's a caveat that if the Medicaid recipient received medical assistance as the result of being a crime victim, that is also a hardship waiver, so they won't take it there. And again, they have other compelling reasons too, pretty much a case-by-case basis, and that will be made that decision is going to be made by the recovery contractor. Order of claims. So this is even if you have a valid Medicaid estate recovery bill and you don't have any exemptions. Do they get paid? Well, they stand behind several folks. So first in line, let's say that you have a Medicaid bill of $15,000 and there's $30,000 in the estate. They don't just automatically get it. First in line is unpaid funeral expenses and expenses of final illness up to $15,000. So the money would go there to pay off the funeral and the bills before it would pay off Medicaid estate recovery. Also ahead of MERP is the unpaid expenses from the estate administrator or guardian, unpaid secured claims and tax liens filed against the home by a government entity, unpaid child support debts, unpaid state and local taxes, and unpaid expenses from a correctional institution. So if the grantor was in jail and racked up a bill there, again, all those come before Medicaid gets paid. Deductions from the claim. So again, it's a valid claim. Are they going to ask for the whole amount? Well, you can actually deduct from that the cost of maintenance of the decedent's home and the direct payment of costs of care for the Medicaid recipient. So again, if you needed to do something to the home to maintain or repair the home, you can deduct that amount from the final bill that Medicaid actually sends you. You can also deduct necessary and reasonable maintenance expenses and taxes for maintaining the home. And again, these deductions must be supported by documentation. So they're not just going to give it to you or take your word. You need to submit proof of that. And again, necessary and reasonable expenses for the direct payment of costs of care provided for a deceased Medicaid recipient that enabled that recipient to remain in their home and thereby not institutionalized or in a more expensive home. So again, you kept them in the home, which is cheaper than a lot of these other alternatives. Going to a nursing home, going to an institution, whatever it is, you've saved the money, so they're going to make a deduction on that. And again, you're going to have to submit an itemized chart of that. So, people are going to have to keep an Excel sheet. In addition to the Form 8001, which again was in addition to the PowerPoint, I've actually included in the presentation some actual letters that have been received from Medicaid estate recovery to the family of a person who has passed away. I mean, this is what happens in real life. When there's a Medicaid bill, they're obviously can't send it to the deceased person. They're going to send it to his or her next of kin. And how it starts is they're going to receive a notice of intent to file a claim. And that notice of intent needs to be filed within 30 days of notification of the death of the Medicaid recipient. So as you can see in the letter, it states that, hey, we were notified of the death of the recipient. So it's not necessarily the date the person died, it's that we were notified on this date that that person died. And then within 30 days of that date, that's when they have to send you out the first letter. What follows that is an actual notice of MERP claim. And in that has to be filed within 70 days after MERP has actual notice of the death of the Medicaid recipient. Now, as you see on there, it actually gives you the opportunity to list your exemptions, your hardship waivers, and things like that. So this is a very important stage for the person receiving a Medicaid estate recovery bill. On the last page of that, you can see where they've actually given you the exact amount that is owed to the government. $19,000, I believe, is what's on this form, whatever it is. But they've also given you areas and paragraphs. Do you have this exemption? Do you have this exemption? And if you do, well, that's the time that you need to tell them about it. And if that's the time that you need to tell them about a transfer on death deed, if that's what you're going to be relying on. You may be relying on the fact that your spouse is still living in the home, or that you are the spouse and you've been given this, or that you are the adult child who is unmarried living in the home for 1 year. Things of that sort. That's the time that you need to present it to them. And then finally, once you do send that to them, and they review your hardship waivers and your exemptions, finally they're going to be sending you either an affirmation of the MERP claim or a withdrawal of the MERP claim. And again, I think what we've included in the packet here is the actual withdrawal of a MERP claim. But very, very important, and it's very important to navigate around that. So again, just wanted to again reaffirm who we are. We're Texas Legal Services Center. We do things for free for folks. All right. Again, a lot of our guidelines, and especially my guidelines, we can help those folks up to 125% of the federal poverty guidelines. But even though we're based out of Austin, we serve all 254 counties in Texas. So do not let geography be a bar to referring somebody to us. We do it by mail, we do it by phone. It works very well. Again, we help all counties in Texas. We speak Spanish. Do not let language be a barrier to helping also. Several of our programs have Spanish speakers. My paralegal is Spanish speaking, so do not let language be a bar either. And again, whether somebody does it themselves on the forms, or hopefully we do it for them, and we would, before you refer somebody to any forms that we might have online, we would like to talk to them first to see if they're eligible. If they're not, we will guide them towards the forms, and we can even answer questions regarding that form, but we would like first bite at it. It's always best if an attorney does it. Whether we do it for free or whether somebody does it on our own, the grantor, the person executing the transfer on death deed, will have two very small costs. And the first one is the form has to be notarized. So once it's filled out, again, whether it be by us or whether it be by them doing it themselves, first of all, you would check with your bank. A lot of times they do it for free. If not, a lot of times you might just have to pay $10, $8, something along those lines. So that's a very minor thing. After it's notarized, again, you can't stick it under your mattress. You have to file it in the county where the property is located. And around the state, that's only running about $30 to $40. So again, for less than $50, you can get this accomplished, whether we do it for them for free or whether they do it on their own. So again, $50 versus a couple $100 for a will is just wonderful. And again, all the additional protections that this has above and beyond what a will offers you is just incredible. Real quick, when I say we can help those within 125% of the federal poverty guidelines, the actual numbers that works out to, if you are an individual, there's one person in the home, if their income is less than $1,256, we can help them. On a yearly basis, that translates to $15,075. That amount goes up with each additional person in the home. But again, you have to take in all forms of income. So household income with two people goes up to $1,692, or on an annual basis, $20,300. For a family of three, monthly is $2,127. Yearly is $25,525. And again, it goes up with each and every extra person in the home. But again, we can help those for free within those amounts. Outside of those amounts, we will refer them to the forms and further guide them that way.